So this is video 2 weeks 6 to 7 contracts, and we're going to finish off by this screenshot video the material regarding genuineness of assent. In the last video screenshot we went through fraud, and we now are at undue influence. And what I'm going to say in these last three topics, or what I want to say generally about these last three topics, undue influence, duress, and adhesion contracts and unconscionability, they do not come up very often, and whether it's in drafting contracts or whether it's in dealing with contract litigation. So we're not going to spend as much time on them as we did on mistake of fact, but particularly fraud. When we're talking about undue influence, it's going to be a concept that arises in a fiduciary relationship. Let me just pick one fiduciary relationship that I have some familiarity with, attorney and client. And the concern is when you have a fiduciary relationship, we have one person in the relationship who's supposed to be looking out for the welfare of the other. So the attorney, how about that, is supposed to be looking out for the welfare of a client. And secondly, in many of these relationships, there can be a power imbalance. And what I mean by that is the client is really depending on the attorney to do the right thing, and the client isn't armed with the knowledge necessarily to assess whether the attorney is doing the right thing. The same could be said about a physician and patient. As one gets a little bit older like me, we sometimes go to the doctor because we have some genuine concerns about our health. The doctor does the test. She or he makes an assessment. And I know we can get a second opinion, but we really have to kind of trust what the doctor is doing. I recently had, it's a really routine procedure, cataract surgery, and during the middle of the procedure on one of my eyes, the doctor said, "Oh my gosh, this isn't working out how I want it to." You know, at that point, I really had to rely upon the doctor. It worked out well. But I'm just pointing out that in these types of fiduciary relationships, there's a real danger that the attorney or the physician or the guardian or the parent, or if it's an old parent, the child, could take advantage of the other. And I remember once drafting a will for a woman who was widowed. She was lonely. She had tons of assets, I might add. And it took some doing to get the will done. She was housebound, so I would visit her at her home, and I realized at some point, because she was lonely, she was looking forward to the visits. She really liked me. She would chat with me. She learned a little bit about my family at the time, etc. And as we're drafting the will, at one point she says to me, "I want to leave you something in the will." And I said, no, you don't. No, you don't. And I talked her out of it. But I think if I had gone down that road, obviously the danger is I would have been, I wasn't tempted, I might add, but the danger would have been I would have been taking advantage of her. She said to me, "Well, let me at least sell you," she was a lovely home, "let me sell you this house. It would be a nicer place for your children," who were then young, to live in. Well, if I entered into a contract with her to buy her house, we have to be concerned about how fair that contract is. And I know I've said courts aren't concerned about the sufficiency of consideration, but they sure are in these types of situations where we have a fiduciary relationship. And essentially what's going to happen is if I had drafted a contract for this lonely widow to sell me her lovely house, that could have been challenged by her family, by the people who were going to inherit the value of that house in her will, and I would have had to prove that it was a fair bargain. And, who wants to be involved in those situations? So I've seen it come up. Now that I'm thinking about it, I once had a client who was the parent, and his kids were adult, and he wasn't, suffering from dementia, but he was getting old and feeble, and they talked him into a deal that just didn't make a contract that didn't make any sense. And now I'm remembering this, and we sued the kids, and we got the contract overturned, etc. So that's sort of a take on undue influence. Problem 14-1 on page 84 will give you an example. And when we get to duress, we have the same thing. It usually doesn't pop up. It occurs when a threatened act, which is not legal, is used to induce a person to enter into a contract. Talking about lawyers again, I think that a good example of duress can be found on page 85, problem 14-7, where a lawyer waits until they're in the middle of a trial and then presses a client into signing a promissory note to pay the balance of the fees. I think that threat was not in keeping with the lawyer's code of conduct, which would have made it illegal, and I think, among other things, duress happened. Final category, adhesion contracts and unconscionability. And when we talk about an adhesion contract, let's make certain that we begin with the observation that it doesn't necessarily mean that the contract can be rescinded, or, if you will, that there's anything legally wrong with the contract. What we're talking about is that the parties come to their negotiations with unequal bargaining power. Where there's unequal bargaining power, the party with the most power, not powder, that's the crime scores, power, can stick the terms to the other party, and that's where this adhesion contract descriptively is used. And as I point out, oftentimes it's just the law of supply and demand will bring about a contract of adhesion. And I can remember the last time I tried to rent an apartment, and I had a bunch of kids, so I needed a large apartment for them to have their bedrooms and to visit, etc. And I wanted it in a certain part of town to be convenient to their high schools at the time, etc. And in relationship to their mother's house. So in the law of supply and demand, when I found the right apartment, it was a rather nice apartment. It was on Bidwell, near Bidwell Parkway in Buffalo, if you know that area, Elmwood area. Very nice. I loved it. Lived there for about 3 or 4 years. But in any event, the landlord held all of the cards because if I didn't want it, he had 3 or 4 people lined up who would have gladly paid the rent. And when you have that imbalance of bargaining power, you're going to have a contract of adhesion. We could, however, have a situation where a contract could be so one-sided that it's unconscionable. What does unconscionable mean? We don't mean that you're unconscious. It means conscience. So unconscionable, as I put, is totally off any moral compass. And a court's not going to enforce a problem that is one-sided. And I point out again problem 14-1, page 84. And to me, that does not only present undue influence, but in all likelihood an unconscionable contract. So I want to again emphasize mistake of fact and mistake of fraud come up. Not mistake of fraud, mistake of fact and fraud come up far more than the other topics. And there's a very useful concept summary set forth on page 83 that will be useful for you. So this will end this video.